Welcome back, future criminologists. In this video, I will be discussing warrant of arrest. What is warrant of arrest? Warrant of arrest is a legal process issued by a competent authority directing the arrest of a person or persons upon grounds stated therein. A warrant of arrest has to meet the requisites according to the law to be considered valid. In the Philippines, the rule on warrant of arrest is embodied in Rule 112 of the Rules of Court and Section 2 of Article 3 of the 1987 Philippine Constitution. What are then the essential requisites of a valid warrant of arrest? First, the warrant of arrest is issued upon probable cause. Second, the probable cause is to be determined personally by the judge after examination under oath of the complainant and the witnesses he may produce. Third, the judge must personally evaluate the report of the prosecutor and the evidence adduced during the preliminary examination. Fourth, the warrant must particularly describe the person to be arrested. And fifth, it must be in connection with one specific offense or crime. Now, let us discuss each of the requisites of a valid warrant of arrest. The first requisite is that the warrant of arrest is issued upon probable cause. What do we mean probable cause in the issuance of warrant of arrest? In a criminal prosecution, probable cause is determined at two stages. The first is at the executive level, where determination is made by the prosecutor during the preliminary investigation before the filing of the criminal information. The second is at the judicial level, undertaken by the judge before the issuance of a warrant of arrest. Probable cause in the executive level was already discussed under the topic of preliminary investigation. Check the description box for the link. Probable cause for the issuance of warrant of arrest is the existence of such facts and circumstances that would lead a reasonably discreet and prudent person to believe that an offense was committed by the person sought to be arrested. Probable cause for warrant of arrest is determined to address the necessity of placing the accused under custody in order not to frustrate the ends of justice. Now we go to the second element. Probable cause is to be determined personally by the judge after examination under oath of the complainant and the witnesses he may produce. The 1987 Constitution speaks of judges, which means judges of all levels. This power may not be limited, much less withdrawn by Congress. The power to determine the existence of probable cause to issue a warrant of arrest is a function of the judge, and such power lies in the judge alone. However, there is an exception. The exception is in the case of deportation of illegal and undesirable aliens, whom the President or the Commissioner of Immigration may order his arrest following a final order of deportation. In satisfying himself of the existence of probable cause for the issuance of warrant of arrest, the judge is not required to personally examine the complainant and his witnesses. Ang i-examine ng judge personally ay kung may probable cause, hindi yung complainant o witnesses. This requisite is further discussed in the next requisite. Now let us discuss the third requisite. The judge must personally evaluate the report of the prosecutor and the evidence adduced during the preliminary examination. Following established doctrines and procedure, the judge shall: first, personally evaluate the report and the supporting documents submitted by the fiscal regarding the existence of probable cause, and on the basis thereof, issue a warrant of arrest. Take note, report and the supporting documents po ang ini-evaluate, hindi po yung complainant and the witnesses. Or, second, if on the basis thereof, the judge finds no probable cause, he may disregard the fiscal's report and require the submission of supporting affidavits of witnesses to aid him in arriving at a conclusion as to the existence of probable cause. The judge has to exercise sound discretion, for, after all, the personal determination is vested in the judge by the Constitution. It can be as brief or as detailed as the circumstances of each case require. To be sure, however, the judge must go beyond the prosecutor's certification and investigation report whenever necessary. The judge must satisfy himself that based on the evidence submitted, there is necessity for placing the accused under custody in order not to frustrate the ends of justice. If the judge finds no probable cause, the judge cannot be forced to issue the warrant of arrest. Next, the fourth requisite, which is the warrant must particularly describe the person to be arrested. The law, constitutional and statutory, requires that the search warrant shall not issue unless the application particularly describe the person to be seized. A failure thus to name the person is fatal to the validity of the search warrant. John Doe warrant. A John Doe warrant is a warrant for the apprehension of a person whose true name is unknown. According to the Supreme Court, a John Doe warrant satisfies the requirement of particularity so long as it contains a descriptio personae or description of the person such as will enable the officer to identify the accused. If there is no such description, the warrant is void. Now, to the last requisite, it must be in connection with one specific offense or crime. This last requisite is also known as one specific offense rule. A warrant, which covers several counts of a certain specific offense, does not violate the one specific offense rule. For example, if the accused committed 6 counts of rape, there is only one warrant of arrest and not 6 warrants of arrest. Scattershot warrant. It is a warrant of arrest that is issued for more than one offense. It is void, for the law requires that a warrant of arrest should only be issued in connection with one specific offense. What is the period of validity of a warrant of arrest? No time limit is fixed for the validity of a warrant of arrest, unlike a search warrant, which is effective only for 10 days. It remains valid until arrest is effected or the warrant is lifted. However, a warrant of arrest shall be executed by the arresting officer within 10 days from receipt thereof. Likewise, within 10 days after the expiration of the said period, the officer shall make a report to the judge who issued the warrant and state the reason therein in case he or she failed to arrest the accused. Ang warrant of arrest ay valid hanggang ma-serve, pero kailangan itong ipatupad sa loob ng 10 araw mula sa araw na inailabas ito ng huwes. Pag hindi mo ito naipatupad sa loob ng 10 araw, may 10 araw ka ulit para mag-report sa huwes kung bakit hindi naipatupad ang warrant. If after 6 months from the issuance of the warrant of arrest and the accused remains at large, the criminal case may be archived. Remedy for warrant of arrest in case it was improperly issued. Where a warrant of arrest was improperly issued, the proper remedy is a petition to quash it, not a petition for habeas corpus, since the court in the latter case may only order his release but not enjoin the further prosecution or the preliminary examination of the accused. This topic is related to our previous videos, arrest in general, warrantless arrest such as in flagrante delicto and hot pursuit, preliminary investigation, and inquest. I'll put the link on the description box. Thank you for watching. If you like this video, don't forget to like and subscribe. Stay tuned.